to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing.
Alright guys, this one's a little different. Today we've got a sovereign citizen who absolutely cannot stop talking and somehow thinks she's above the law. She spends the entire hearing interrupting the judge, talking over everyone, and snapping at the officers like that's going to magically help her case. Spoiler alert, it doesn't. And the best part, the judge is having none of it. This guy is completely no nonsense, and by the end of the hearing he drops a sentence on her that she clearly did not see coming. It's brutal, it's deserved, and it's honestly satisfying to watch. So let's dive in and watch this sovereign citizen talk herself straight into disaster while the judge shuts it all down in real time. And while we're watching, let me know in the comments what you think her IQ is, because I've got a feeling it's struggling to compete with room temperature.
No, come on out. This is the date and time set for sentencing. The records show the presence of the defendant. Our advisory counsel is here. And Mr. Wagner, are you appearing before the state?
Yes.
This is the date and time set for sentencing. Good.
Excuse me, how you doing?
No, I'm talking now. Listen to me. Is your true name and your complete name Shayna Marie Blackshire?
The court lacks jurisdiction over the subject matter.
What is your date of birth?
The court lacks jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacks jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22209. Count 1, unlawful flight from a law enforcement vehicle, a Class 5 felony. This is in violation of ARS 28624C.
Y'all cannot force me to get sentenced.
Yes, I can. ARS 28622, ARS 28622.01, A1, 28624C, 283001, 283304, 283305, 283315, 13701, 702, and 801. The date of the offense was on or about February 5th, 2022. The offense is non-dangerous, and I'm finding it non-repetitive for reasons I'll state on the record. Count three, that she is guilty of count 3, criminal damage, a Class 1 misdemeanor. It's in violation of ARS 13-1602A1, 13-1601, 13-707, 13-802. And she's also guilty of count 4, burglary in the second degree. This is a Class 3 felony in violation of ARS 13-1507A, 13-1501, 701, and 702, and 13-801. The date of the offense was on or about February 5th, 2022. Judgment of the court that she's guilty of count 5, resisting arrest, a Class 6 felony in violation of ARS 13-2508, A1, 13-701, 702, and 13-801. The date of the offense was on or about February 5, 2020.
Excuse me, advisor. Why is they allowed to do such things?
2022. The offenses are non-dangerous and non-repetitive. The reason I'm finding them is the microphone off, Louis. By the way, turn it on.
Excuse me, that's illegal. Y'all can't
All
do
right.
that.
No, that's on now. Turn
Yes,
it on.
it is, Justin.
All right.
This is exactly what happens when someone who thinks the entire world revolves around them finally runs headfirst into reality. In her own mind, this sovereign citizen is the victim, no doubt about it. You can tell just from the sheer audacity she's radiating. Walking into a courtroom, yelling at the judge, talking over the judge like rules don't apply to her? That's not normal behavior, especially when you're staring down the possibility of years in prison. And let's be real, nobody wakes up one random morning and decides, yeah, I'm going to reject all laws, authority, and basic social norms today. That mindset takes time. Years of reinforcing bad ideas, zero accountability, and never being told no. This didn't happen overnight. Now, I'm not trying to play internet psychologist here, but if I had to guess, this kind of behavior usually comes from a lifetime of entitlement and zero consequences. Someone who's never had to respect authority suddenly being forced to, and completely melting down over it. Let me know what you guys think. Am I off here, Or does this feel like textbook main character syndrome finally crashing into the real world?
So the offenses are non-dangerous. I'm finding them
Why you allowing that?
I'm finding you're your own lawyer. He's not your lawyer. He's nothing going to do it. I'm finding that they're non-repetitive because I believe that these cases, all of the charges in this case and in CR 2022-208, which is the prior case for which the defendant was convicted, these cases all of those charges could have been brought together and tried together, but they weren't. I'm not criticizing the decision. It is what it is. It happened for independent reasons, but I'm finding that they are not repetitive. All right. So,
I don't want to participate in this. Y'all have to let me go.
Mr. Wagner, do you want to be heard on behalf of the state?
I do, Your
Get
Honor.
out of here. I refuse to proceed.
And if the victims wish to be heard, we have victims here in the courtroom, a victim, I think, I'm not sure.
No, Your Honor, she's
they're not.
outlasted the victims.
I'll ask the victim. Do you wish to be heard?
The victims have had to return back to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing, but she is her own attorney, and she's drugged us out long enough that the victims aren't here to give a statement today.
Right, so y'all can't do that. Y'all cannot force me. Y'all can't sentence me like this.
Ms. Blackshire, I believe that these are repetitive and that she should be subject to the Category 2 repetitive offender statutes. She committed these crimes. She was taken into custody for the first crimes, the 208, Your Honor. She was taken into custody for 208. She made bond and was released on bond. And then she committed these separate offenses while on felony pretrial release.
I just want to make clear, to save your words, I do intend to impose the enhancement of 2 years for the crimes being committed while on release. So I just want to...
All right, thank you.
If there was any confusion about that, I wanted to straighten it out. I apologize for interrupting you, but I thought it was something to clarify up front.
This is illegal.
I believe that it's more than warranted. She was sentenced. Those were separate cases. She was released from those cases, and she committed the new cases. Not only did she commit these crimes separately from the other crimes, these crimes significantly, especially the burglary, I believe substantially affected the victim. The victim, the owner of the property at Morningstar Ranch. Yes, she was burglarized before. No real property was taken from there. As you heard, you sat through both trials. But in this case, in this burglary here, count...
Let me out of here. I don't have to proceed with this. Move. I don't have to.
Count 4, Your Honor.
Let me out now.
The defendant confronted the victim at her home and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor, to acknowledge
Hold
that.
on, sorry. I'm getting... What's that?
Are you going to allow
No, I'm talking to you. Why are you taking her out? You're not? Okay.
But I don't want to be in here.
Staying in.
Requested to leave.
Oh, you're bringing the chair in. Okay, that's fine. I apologize, Mr.
That's fine, Your Honor.
I was getting signals from the defense.
That's fine. I also would point out to the court that the unlawful flight from law enforcement...
All right, stand by. Apparently they're going to restrain her and bring her back in. Thank you. All right. All right. Defendant is back. You may continue, Mr. Wagner.
Thank you, Your Honor. I would also point out to the court that count 1, the unlawful flight from law enforcement, and count 5, the resisting arrest counts, are not in any way connected with the prior the 208 case. They're separate victims there. These are definitely separate incidents. The state would argue that as well for count 4, the burglary, Your Honor.
No, I'm not relaxing up. This is illegal. The court lacks jurisdiction over the subject matter. Y'all don't have no right. Get this shit off of me.
Get that off of you. Seriously. Maybe if she wasn't behaving like a 4-year-old having a meltdown because Mickey Mouse got turned off, she wouldn't be strapped into that chair like a complete hazard to everyone around her. And when I say like a maniac, I'm not exaggerating. Just look at her. If someone ever conducted a psychological study on sovereign citizens, she would be the cover photo. Honestly, I wouldn't be shocked if she thought she invented the movement herself. But the most outrageous part of this entire situation is the sheer waste of resources. She has 7 officers tied up dealing with her antics. 7. That's half a police department babysitting one walking headache while real crimes are happening elsewhere. Someone's probably getting their car stolen across town. But no, everybody drop what you're doing, because Queen Delusion needs attention. And frankly, she should be billed for it. The cost of those wasted hours alone probably exceeds whatever she paid for that fake diplomatic immunity card she ordered online. You can see it on the officers' faces. They are completely done. Still, they are handling it with the patience of saints. Personally, I'd be asking for hazard pay after sitting through this circus.
If I could have just a second, Your Honor.
I ain't never been fighting with y'all.
What's the statutory reference to the 2-year enhancement? I can't remember that.
It is, I'm sorry, Your Honor, it is 708D. And I don't know that I made that entirely clear, but it just, whatever the sentence, the court prescribes, each sentence gets a 2-year enhancement.
Is that ARS 13-708?
Yes, I'm sorry, ARS 13708.
It's illegal.
But not as to the misdemeanor, obviously.
Not as to the misdemeanor. I concur with the misdemeanor assessment that probation had, that it's just time served in the county jail, that she's already fulfilled more than the requirement for that. I agree that the presumptive terms are warranted in the other cases as well, Your Honor. I would point out that the jury during the aggravation phase, the jury found 4 aggravators. They found 4 aggravators. We have no mitigators here that I can see. Even with all of that, I would still ask for the presumptive terms as a Category 2 repetitive offender with the enhancements for the 13708D. I think that these charges probably would be warranted to run concurrent with each other, but I do feel that they should run consecutive to the defendant's prior case. She caused more harm and more emotional stress to the victim, the owner of the property, and then we have separate victims as to the resisting arrest charge and the fleeing from law enforcement charge, Your Honor. I don't have anything more to add than that, and there's no victim's presence. There's some representatives, some neighbors, some people from the Morningstar Ranch that are still living in the area. They're present here today just to watch, I suppose.
Very well. Thank you very much. All right, the court imposes a sentence as follows. As to count 1, unlawful flight, a Class 5 felony, the court, as I said, finds the offense to be non-repetitive, non-dangerous. The court imposes the presumptive term of 1.5 years in the Arizona Department of Corrections. The court imposes an additional 2 years sentencing enhancement because this offense was committed while the defendant was on pretrial release, and that's pursuant to ARS 13708D. So the total sentence as to count 1, Class 5 felony, is 3.5 years. As to count 2, this is the misdemeanor criminal damage. The court imposes a sentence of time served. As to count 4, again, the court finds this to be non-dangerous and non-repetitive. This is burglary in the 2nd degree, Class 3 felony. The court imposes the presumptive term of 3.5 years. The court also imposes the sentencing enhancement pursuant to 13708D of 2 years. So the total the total sentence for count 4 is 5.5 years. As to count 5, resisting arrest, it's a Class 6 felony, non-dangerous, non-repetitive. The court imposes the presumptive sentence of 1 year. The court further imposes the sentencing enhancement as required by law under ARS 13708D for 2 years, for a total of 3 years as to count 5.
If you enjoy content like this, make sure to leave a like and subscribe to the channel. It really helps me out a ton, guys. Let's get back to the video.
The court further designates that the sentence imposed on counts 1 and 5 are to run concurrent with each other. That is the unlawful flight and the resisting arrest. The sentences in counts 1 and 5 are to run concurrent with each other. The sentence imposed on counts 1 and 5 are to run consecutive to the sentence imposed on count 4, which was 5.5 years as to burglary in the second degree. So the sentence imposed on counts 1 and 5 is to run consecutive to count 4. The court imposes the sentence imposed on count 4 in this case, which is burglary in the second degree of 5.5 years, is to run consecutive to the sentence that was imposed in case number CR 22208. Right, so the sentence imposed as to count 4 in this particular case is to run consecutive to the sentence imposed in case number CR 22208. That's because this defendant was released in the prior case, 22208, when it was a justice court case. She was released when she posted bond on July 7th, 2021. She failed to appear and a warrant was issued for your arrest on October 20th, 2021. The events in this particular case are alleged to have occurred, I believe, on February 5th, 2022. So the events that happened at the Morningstar Ranch that were the subject of 22208, do you wish to have an attorney appointed to represent you on the appeal? If you cannot afford to pay one, the court will pay the cost of an attorney to represent you on appeal. That will include the cost of the lawyer's legal fees and legal costs. You will not have to pay anything. Do you wish to have an attorney appointed to represent you on the appeal? No. Appeals are specialized actions, and Court of Appeals is very sticky with their rules. They're very strict, and it's a real specialty with someone who knows how to write good appeals. I met with you before when you were here before, and we met not in chambers, but in the holding cell area. It's all on the record, what I'm referring to, and I advised you that it really is in your best interest, I believe, to have a lawyer represent you on appeal, and you indicated at that time that you don't want a lawyer to represent you on appeal. I'd really encourage you to do it. I think it's in your best interest, but it's your choice. Okay. You're excused. You're remanded to the custody of the sheriff to be delivered to the Arizona Department of Corrections to fulfill a sentence. What? Hold on a second. What?
How much time did you give me? You just said a whole bunch of numbers.
Yeah, you can take them. You're excused. Thank you. Good luck. All right. I'm not having the defendant step forward to sign for notification of her rights and to sign the judgment in this particular case. She's consistently throughout all the proceedings in the Justice Court and in this court as to whenever required to do so or asked to do so, refused to sign anything. So that would be fruitless to ask her to do that. But the record will reflect that I've advised her of her right to appeal, the right to have an attorney represent her on appeal, and I think that's all we're going to do. And I don't see any point in having her trying to sign these documents. That's just not going to happen.
I don't either.
I think it'd just be disruptive to the court proceedings. Okay. Anything else? All right, we're adjourned. Thank you, Albert.
If you're enjoying this kind of content, make sure to hit that like button and subscribe to the channel. It seriously helps support the channel more than you think. Now, let's jump back into the video. School. Honestly, the wildest part about all these sovereign citizens popping up is that it's not even shocking anymore. It feels like every single day there's a new clip of some self-declared free inhabitant yelling about maritime law while getting hauled away in handcuffs. And let's be real, most of this nonsense comes from a mix of political brain rot and broken homes. You can agree or disagree, but a lot of these people clearly grew up binge-watching conspiracy videos instead of learning basic life skills, like following the law or respecting authority. Now they genuinely believe they can just opt out of reality and dodge consequences by saying magic legal words. Spoiler alert, it doesn't work. Sovereign citizen logic holds about as much weight in court as a Monopoly get-out-of-jail-free card. Honestly, that card might be more convincing than the garbage they argue. And if you're ever wondering whether sovereign citizen arguments actually work in court, let me save you the suspense. They don't. Ever. Judges have shut this stuff down over and over again. Diplomatic immunity claims, strawman theories, rejecting citizenship, it's all legally meaningless. What they are doing is basically playing legal Jenga, pulling random blocks of nonsense until the whole thing collapses right on top of them. But yeah, I really want to know what you guys think about this one. This hearing was intense, and I honestly haven't seen behavior this unhinged in a courtroom in a long time. Drop your thoughts in the comments. I love reading them. Take care, and I'll see you guys in the next one.